to share with the permission of the chair. They say that thinking outside box, thinking. So it came to me, thinking inside box is bondage. Thinking outside box is freedom. So today I understood box is breakable, that is adventure. But I will come to an understanding that box is an illusion, that is liberation.
Okay, anyone else, please? Yes.
I just have a few observations for different sets of people. To Anup, I was saying that, yeah, it's an important one for law teachers to understand that students go through trauma, and not only in clinics, even in the research work. And I learned this through my exposure to sociology people and social work. When we went for a project when after the Gujarat earthquake, the university had a project, and we had many students breaking down just seeing the devastation. And the social work school from Jamia, they had a proper setup there to support. Then I saw a sociology student, Pratiksha, was doing the rape observation, and in her plan of action for PhD work, she said 6 months recovery from interviews. And we as lawyers, we don't even know, we have gone into social work, we have gone under the law schools, but we have not actually picked up that. It's a very important one that you made, and I wanted to re-emphasize that all of us who are exposing our students to society, we have to really focus on that. And I thought there is a very important lesson in the way your clinic and your work has developed, because I was talking to Professor Rahul yesterday, and most of us are now, not most of us, all of us are required to run clinics, but what about the continuity? We are going to a community clinic, our students are available only for a certain time. And then, unless we employ additional staff, a permanent staff to look after that, these clinics are just a bar council tick off, but actually not working. So what are the mechanisms that we need to and I was referring to Mr. Rao because he is in the position where he can set a pattern again following this. As a Vice Chancellor, people are better capable of addressing these issues rather than teachers who are running the clinics as such. So I think there are very, very important lessons from there, and we must. And I certainly agree with this observation of Anup. Education is the business of educators. The others are there to support. And I really had a good fortune of going to the academy as an academic and then change their systems. Because what they were doing was reinforcing the what I call as hereditary knowledge. That one judge passes the same information, the lawyer passes the same information. But if you have outsiders, not in positions of necessarily power, but certainly influence. So having lawyers, judges, etc. in our panel are important, but to give them positions of decision making is not the right thing. They can share their experience so that educators can adapt the education to suit the requirements of the profession of the judging and the lawyering or whatever, wherever they go. But I think the decision making has to be in the flexibility in decision making. I am Delhi University, I find it very difficult to budge because the systems to know there's a professor who goes outside, there's a specialized work, acquires a lot more new knowledge, and then he comes back to the university. We have 26 courses by Bar Council. There's very little flexibility in introducing new courses and say, well, these are important courses, or no, this person has acquired specialization, so they should be able to offer courses. So I think somewhere this was strict somebody else setting the agenda for what my university or what my institution will set up. That has to loosen up. I certainly think we need to focus on the specialization of teachers also for developing new areas of knowledge, and we should have lesser control because in Kalpesh, there was a huge bureaucracy there again. So you replace one bureaucracy with another, and that's not going to be very helpful.
Yes, please. Yes, Professor.
Thank you. A very good morning to everyone. Sorry, I didn't come to this conference. Well, I just wanted to tell something about that the point that has been made by Mr. Arvind regarding judicial interference in the matter of legal education. How much it is expected. I think this essentially falls within the broader idea of the periphery of judicial review, that to what extent judicial interference is really expected in different other matters. And And so long the judicial interference, brings a good result. There is no bad in this, and it is usually believed that if the executive or legislative becomes lethargic in some cases, then a little bit push from the back by the judiciary rather helps the society. So there is an interesting case law in Bangladesh regarding this judicial interference in the legal education. That case was finally decided by the Appellate Division of the Supreme Court of Bangladesh, and it was in fact about a private university that is called as Darul Islam Private University that used to sell in fact certificate instead of disseminated education, because they know that in Bangladesh what happened that after the establishment of the Private University Act back in 1991, after 2000 it has been mushroomed in Bangladesh. There are a lot of private universities which are established, and out of 104 private universities, 70 private universities introduced law courses. And the question was raised by some of the academics that who are going to run these law schools? That's the big question, that who is going to teach there? Because earlier it was believed that even 4 or 5 public universities could not run properly because of lack of appropriate experts on different aspects of law. So that was a big question. Well, so at some point of time, that case was brought before the High Court Division, and the High Court Division decided on the issues regarding that particular university, but at the same time, it gave some observations regarding the inter-legal education. Well, interestingly, that was appealed before the Appellate Division, and Appellate Division inter alia said that no university can recruit more than 50 students in a year. In a semester. So one university can recruit 100 students every year, divided into 2 semesters or 3 semesters, whatever. Well, the motive or the objective of the court behind making this decision was really good, because the court thought that universities were not properly equipped to deal with hundreds of students, so it has limited number of the students. But the question is the strength of each and every university same? So if one university was established back in 1996, like Northside University or some other very prominent, very good private universities, which are in Bangladesh, if they have the strength of maybe, educating 200 students, and maybe another X, Y, or Z university does not have that capability to run with even 100 students. So that's the point that the court eventually, we thought that the Appellate Division is going to rather formulate a wider policy regarding private universities, which the court did not do. So we became happy at the very outset of that case that perhaps we are going to get a framework to bring all private universities into the framework, so that they would become properly to disseminate justice education instead of legal education, literally in literal sense. But Appellate Division did not do that finally. So the eventual impact of that particular case is that the positive impact is that the court has interfered in this matter. The negative impact is that after getting this court judgment, now everyone is believing that, well, if I establish a university, then I can teach 100 students, so there is no other requirement, whether justice is being properly educated or not. So the conclusion is, just like any other judicial activist cases, that if that particular judicial decision can bring some really good result, that is fine. If that becomes a bad one, that rather acts in a negative way. Thank you very much.
Yes. Thanks, Mr. Chair. Good morning, everyone. I was just referring the remark made by Anumji on the aspect of interference or bringing judges in legal education. I personally and firmly believe that legal education has many purposes, but one of its principal aim is to empower, enable proper and purposeful justice delivery system. So when ultimately a law student, at least some of the law students, are going to give strength to justice delivery system, the partners of justice delivery system or the actors of justice delivery system, that is judges and lawyers, they must be there in the legal education, because of their presence, we will get a clear way as to where to lead the legal education. Legal education does not essentially mean only academics. academic excellence is useful in justice delivery. But at the same time, along with academic excellence, many other components are required for complete, purposeful and effective justice delivery system. Therefore, I believe that in legal education, we really need outsiders also, because we may not put them out of the fence, maybe judges or lawyers. If they are in, we will have better strength. That's my personal opinion.
Asha, may I make one point? And I want to also point out Sachin, who's had his hand up here for a while.
My hand was just actually saying that.
Okay, thank you. So two very quick comments. One is directed towards Anup and one is directed towards Tara and to all other panelists. So the comment to Anup is, firstly, thank you very much for coming. You're a very busy and important man, so good to have you here. Now, but what I want to
yesterday. Professor Pandey was anxious that he reach here now.
Yes. So what I want to focus on is, I think the Project 39A has done many things that are unusual, right? Firstly, you're working with large sums of money. You're working with full-time professional litigating staff located within a university. Now, I think I read about some Agami funding also coming to 39A. So you're breaking out of the university funding structure. You are comfortable with moving with uncertainty when it comes to what does this mean for a student's learning outcomes. All of these things are very, very cool. They're very, very new. And this is what I honestly believe more law schools and universities in general should be doing. Not playing by the games of the rules of the game in that sense. So my question to you, that's the stuff that I think you identified but left unsaid. What allowed you to do that? And I'm sure partly it's your vision, partly it's the NLU maybe director or some other leaders there who bought into that vision. But if at all we want this to happen in 10 or 15 or 20 places across the country, is there some way with that enabling ecosystem, for lack of other words, can be quickly recreated? Because if the magic happens only with one 39A and one NLU Delhi, it's not going to, in a dramatic sense, tilt the scales of justice at a macro level. You will profoundly change many people's lives and transform many students' lives.
Okay, can I just add something to that question before Anup gets there? I think that we've been talking about educating, justice education, but I think Anup is also hinting at something, and I'm going to just say it out loud, which is universities as platforms for change. So we are talking, like, the conversation is always universities as a platform for educating justice agents, but the university as a platform for change, because the university has access, the university has a certain sense of security, the university has a certain legitimacy, which allows the university to function in a certain way. Some independent company or organization started doing what Anup is doing, maybe it would have been bust in 1 year. So why I'm thinking that universities as platforms for change, not just universities as platforms for educating change makers, is an important transition to make. Your sister had a transformative experience not because she learned something, because she did something. So the point I'm making is that, So the point I'm making is that we can't conflate that with saying she learned some nice things. She may have got great insights, but nothing, the data is out there, which is, Ashoka, for instance, did this huge survey across fellows. And the fellows all pointed out one thing, which is when young people have an opportunity to do something early, actually participate in a process, not just learn something, but actually participate in a project or process, they're fundamentally altered in terms of the choices they make subsequently. So I think that if we can just kind of recognize that we're leaving something on the table, if we look at universities as just platforms for education, universities can be in India legitimate platforms for change.
May I just intervene quickly?
accept to be a bad chair. We have exceeded 15 minutes of our time. So we are
quickly request everyone to please
Asha, can I just intervene for 1 minute? You know, for me there is a big concern, especially on this issue of human rights education. I've been party to HRE education, and Samarth, I want to deal with this from you. Human rights is the dirtiest word in India today. And let's face it, those who sort of are, we are the human rights walas, we are anti-government. Let's face it that this is the identity we have built. What has the human rights education done to build that negative identity? What I would like to ask. How do you build a positive identity of people who believe in human rights? Right from school to young people, how many in the colleges here, even law students, say, I am a believer in human rights. It sends so many mixed messages, given how the politics today has confused the issue. Do you have an alternate paradigm, alternate pedagogy, where either you throw the word out, bring in citizenship, constitutionalism, whatever you want, rule of law, or then do something very dramatically different where human rights is respected from the family upwards to business houses. I think you need to reimagine, because I am both a perpetrator and a victim of that process.
I request Professor Surendranath and Samarth to quickly respond.
So I'll just take Sachin's question first. Absolutely, I think we're very clear that Project 39A is a site for change, and it's located within that, and the education mandate is subservient to that, right? It's always serving that purpose as far as they go together, right? And that's it, absolutely, it's not seen as a educational initiative. It's very much university's mandate to provide legal aid, kind of comes from there. So absolutely, in terms of to Abhay's question on what made them do it, right? And I think it's just very shrewd thinking on this can get us attention, and this can get us a certain reputation for promoting research, and that has played out, right? And that has played out in terms of just getting a very young university to fully back it, to say, fine, I mean, and to give us that kind of flexibility. And I think, but more fundamentally, it's that, see, with government grants, right, you're not going to be able to do this scale and this kind of work, right? Our annual operating budget is quite significant. I mean, it's a good challenge to keep it going year on year, right? And to say what, and to break for universities and law schools to break out of this dependence on government funding, right? Or ICSSR funding, or UGC research, whatever other, that kind of money is too small to do high impact work, right? And I think that needs to be acknowledged. Very often that is not. We say, okay, we want to do good quality work, but where is the corpus of money going to come for that, right? And I don't think law schools have been innovative enough in trying to raise funding from various sources that they could, right? And I would say that a lot of hesitation in other law schools taking this sort of thing would also be, okay, who's going to pay for all of this, right? Even if it's going to say, okay, it's going to bring us a reputation that we're also a research university in addition to being a teaching university, but where is the resources going to come from? And government funding, with the story of how much governments are funding each of the national law schools is evident, and with that kind of funding, you're not going to be able to do much, right?
I know there's a lot of issues.
We need to discuss it perhaps at
Yeah.
May I request
Samarth?
So I'll answer both equally. I completely understand the problem around human rights. Our focus, but human rights cannot be, human rights education cannot be eliminated just because of the climate that we live in. It's very important. So our approach is basically to promote peace and rule of law through E4J. And there are two approaches to human rights. One is through activism, and like having an anti-government stance, which of course is a very important, very important element of activism as well. The other is also to create or engage in dialogue rather than debate, engage in more of focusing on solutions to some of these issues. So UN provides a forum to young people. There are so many youth forums that are happening at UN where we are getting people from the communities, youngsters from the communities who are showcasing who are presenting their voices, who are showcasing their initiatives to the member states. So that's one way in which we deal with this. With regard to your question, I understand my sister, of course, I mean, there was a lot of, she did work, so she generated this interest. But it was also because she was sensitized on these issues earlier, based on which she could get that initiative or drive inside her to work on this issue. So that is what we are also building. We are like the first stage right now, sensitizing young people first on issues, getting them thinking on these issues, and so that they can figure out what they want to do. And then when they do, we of course co-create projects and solutions with them. So these are the
To continue the discussion, maybe over lunch or tea, what I want to just conclude by saying, yes, if we do clinical legal education in project mode or any justice project in a project mode, it is the sustainability is an issue. We, for instance, in our project, similar to what you are facing, we had a lot of research done, lot of data gathered, lot of protocols made, models of justice made, but once the funding, either the funding agency looks at numbers, many times, that's the issue, numbers, they are more interested in numbers, or you have a change of leadership and they need time to decide whether such a project should go on or not. So in that interim period, the project is shut. Yes. Thank you. Thank you.
Panel. We have 5 presentations in this panel and 6 presenters. 2 of them sharing paper. This is an interesting panel which is focusing on working with communities and appreciating context. It's a diverse panel with speakers from India, from the Maldives and from Bangladesh. So let me welcome all the panelists very quickly. I'd also like to point out that we are running half an hour behind schedule and we hope to finish by 1:30. That's all right. Is it moving here? Yeah. It's okay? All right. So then, without taking up any more time, let me invite Dr. Mariam Jabin, who will be speaking on the future of justice education with special focus on the Maldives. She is the Secretary General of the Bar Council there and has been working on justice education for a few years. So over to you, Mariam.
Thank you. Thank you, Professor Dr. Can you hear me?
Yeah. Maybe you stood there slightly closer to you.
Is this okay? So, I'm going to talk a little bit about the human rights of vulnerable groups in the Maldives and how a clinical program of clinical legal education can advance the situation of human rights for vulnerable groups in a country like the Maldives. In 2014, a study on access to justice in the Maldives found that access to justice of vulnerable groups in the Maldives was significantly affected due to the lack of information, accessibility, legal representation, legal aid, and affordability. The provision of state-funded legal aid is only available in serious criminal cases only. And the situation of our country is we are 1,190 islands, over 9,000 square kilometers of sea area. This makes the situation in the country quite peculiar in terms of providing services, outreach, especially to vulnerable groups such as women, children, and also other vulnerable groups. So, if I look at the situation in the country, we have made significant achievement in terms of economic, social, and health related development in the country, and also in terms of political and civil rights in recent years. However, in terms of women's empowerment, strengthening justice and legal mechanisms, we are quite behind still, and we have a lot of catching up to in terms of economic development in the countries. We have also made significant progress in terms of creating legislative reform. We have a Domestic Violence Act, we also have a Child Abuse Prevention Act, we have a Sexual Offences Act, we have a separate Family Protection Authority looking at the issues for vulnerable groups such as women and children. So all of these mechanisms are coming into place, whereas we don't see the same change operating around the world for these groups of people. If you look at the situation of women and children in the country, studies show that child sexual abuse and exploitation is quite high in the country. These studies show that 1 in every 7 children in school between the ages of 14 and 16 have been sexually abused, with over 12% of women reporting that they were sexually abused before the age of 15. The ministry, where I was working previous to the Bar Council position, the Ministry of Gender and Family receives on an average 200 cases of child violence against children every month. And for a country with a population of about 380,000 people, that's quite a number. So it is a serious concern for the country. In terms of domestic violence against women, we reflect the international numbers, which is 1 in every 3 women suffering physical or sexual violence, and 1 in every 5 women report that they are from intimate partners. So we have a serious case of women and children. I am going to look at three groups in this presentation. The other group which I look at is migrant workers, which Gagan was also mentioned yesterday. The situation of migrant workers in the country is also very acute. No one actually knows the official number of migrant workers in the country, particularly the number of Bangladeshi workers in the country. Whereas the state suspects that we have about 150,000 Bangladeshi workers, most of them undocumented. Bangladesh would say it will be well below 100,000. However, in September 2019, the embassy itself has submitted to check the documentation for 40,000 Bangladeshi workers in the country, which means they are also undocumented. So we have a serious concern in terms of many of these workers who we now say have been trafficked into the motives or in some form of forced labor or some form of international or national crime in that. This is also a serious case in the country. Many of these will have language barriers if they are taken into custody. They will not have their documents because usually passports or any identity documents are taken by the employers or they are kept with them. We also have a lot of issues of these workers running away to other islands because they want to find other opportunities which actually pay them better. Usually they are employed with $100 to $150 bracket. That's a very small salary for a month. So this is just a very small snapshot of some of the issues for some of the vulnerable groups in the country. My proposal for the law school, I have been involved in some form or the other with legal education for the past 15 years in the country. My first employment was in the Knowledge National University, where I tried to introduce some of these programs. Most of them still focus on enhancing or providing or creating legal literacy in communities, but this is very, very limited in terms of what we want to do. We have a very traditional approach to teaching law, and if I can define legal education in laws, it could be traditional pedagogy with no focus on practical skills and very far from justice or human rights components. So in this situation, it is very hard to introduce these models into the current curriculum or the current legal education in the country. However, I had four ideas to integrate legal education into the current framework in the country. The first would be be a clinical legal education extension program in which law schools can actually partner with civil society organizations or law firms actually providing pro bono legal services. The situation in the country is no law school actually has a clinical program. However, some NGOs have clinical programs. For instance, there's a family legal clinic in the country, there's a public interest law center, and there's also a program for migrant workers in the Transparency International Maldives chapter. So there's some form of services available to these vulnerable groups. However, if you imagine or if you think about the situation of the country and how dispersed we are, it is very difficult when all of them are based only in the capital city Malé. The other major issue is all of the lawyers are also based in the capital city Malé, with just about 10 lawyers in the southern tip at Blue Atoll. The rest of 16 atolls have no lawyers, which means that no legal services are provided or available to these groups, even for a charge. So the situation is quite acute. The second would be the clinical legal education program, teaching program, community teaching program, where students are involved to reach out to these groups. The third would be an in-house legal consultation program. I'm sorry, I'm rushing because there's a ticking. In-house legal consultation program for these groups. The Gender Ministry actually has a family and gender service center in every atoll, which means about 20 centers one in each atoll. However, the staff there's 1 or 2 staff per center, which means one staff has to cover an entire atoll. And sometimes if it is like 10 to 12 islands, and there's a serious case which has happened in one island, that person has to wait for transport. Sometimes they also have to wait for the weather to calm down, and because you have to take sea transport and you can't fly out either because they're very small islands and there's no way you're going to land anywhere. So there's a lot of challenge for these service providers when we wait. But I think if we have a clinical legal program in the university, their outreach can be better than the lawyers' outreach currently, because the university has campuses in all major centers in the country. And there are students studying in these campuses all over the country. And if we take 5 major centers, I think their outreach can be significantly better than any of what we are trying to do in the capital city Malé in terms of reaching out to these people and vulnerable groups in time to provide any services. I won't talk about 2 specific cases either, but I think I'm going to bring it up and maybe we can discuss that in the discussion. Thank you.
Thanks, Mariam. I think, all that you have said on women and children and migrants from Bangladesh all resonates in, the present environment that we have in India. And I think all across the region, the low focus on practical skills and the fact that we are far removed from human rights is also something that, is cross-cutting. And it's interesting that you have hope that the CLE program in the university will have better outreach than lawyers do. And I think, you're looking at CLE more as a justice delivery mechanism than a teaching mechanism, which is, I think, been one of the major themes over these last 2 years. So thank you so much, and we look forward to hearing more about your cases through questioning. So we now have our next presenter, Professor Mohammad Ikramul Haq. He'll be speaking on legal education in Bangladesh, problems and prospects. He is a professor of law at the Dhaka University, and he coordinates the Dhaka Law University clinic or the CID project. So over to you. What I would suggest is maybe, use this mic, this seems to be working better. So just see if that works. I'm going to just switch.
I don't think you can see more strong. Yeah, it's working. Yeah. Well, a very good morning to everyone, and I did apologize at the very outset of my lecture because I didn't participate in yesterday's sessions, which were very useful. I'm sure about that, and that, in fact, in my opinion, based the entire framework for the complete. Well, since the time is very much limited, 10 minutes, so I wanted to speak about a lot of things. Perhaps I could if I would have joined from his study. Anyway, so I'm rather thinking about sharing some ideas, thoughts, and some of my experiences with you people in 10 minutes. Well, the first thing that I'd like to say, that is about the title of the conference, of this conclave, that is the future of justice education in South Asia. I like the title very much, because the organizers could make the title like the future of legal education in South Asia, but they did not make it. I think they did not make it deliberately, because they didn't want to focus on legal education, rather justice education. So is there an essential difference between justice education and legal education? I do think that there is a difference between justice education and legal education, because legal education may be purely clerical, that we are just educating some laws to the people, and justice education, it means that we are educating the people law in a good way, and those laws are also good laws. So essentially, I'd like to focus on the idea of having a set of good laws and a set of bad laws. That means there should be some difference between a good law and bad law, and there should be some difference between the good way of injecting the ideas of law in the minds of the people and the bad way of injecting the ideas in the minds of the people. For example, if we talk about asking a remedy before a constitutional court, for example, we can think about the Indian Supreme Court, that the law says, legal education says, well, someone has to apply before the court. But justice education says, if the judge is well informed about what the violation of any human rights or constitutional right, then the judge may proceed suo motu. There are a lot of renowned cases by Indian judiciary in that regard. So I think that some judgments have been pronounced by Justice Krishna Iyer, Justice Gajendra Jadkar, or some judgment like Nilavati Behera case. So there are some very progressive judgments where the court said that, well, I can entertain a particular issue even without having any sort of formal application. So this, I'm citing this example just to make my idea clear before the audience that there is a difference between legal education, legal provision, and justice provision. Well, the second thing that I would like to emphasize is in which sense justice should be construed, because I strongly believe that if we can formulate a theoretical and conceptual framework of justice first, that eventually lead us towards a destination. So before we actually starting for injecting the idea of justice in the entire legal education, we need to sort out that which should be the format of justice. I mean, justice in narrow sense, justice in wider sense. That means I would like to focus on the idea of thin rule of law and thick rule of law. So in that sense, I'm in favor of accepting the idea of justice from the perspective of thick rule of law. That means only with a set of good laws in a good way of application. And I'd like to also focusing on three popular dimensions of justice, which appear in both the constitutions of India and Bangladesh at the same time, because, I mean, the constitution of Bangladesh, which was adopted back in 1972, was largely influenced by Indian constitution, and that speaks about establishing justice, that is the trajectory of the constitution. Well, so justice in three different senses used in the constitution one is political justice, one is social justice, and most importantly, the third one is the economic justice, which Dr. Ambedkar specifically mentioned in the Constituent Assembly debate, that I'm setting all these directive principles in the Constitution in order to achieve the target of economic justice. The same thing we have done in Bangladesh. So whenever we teach law to the students, we must be aware of the fact that this is the trajectory of the state, that we must achieve the target of economic justice eventually. So the application of law should be considered from that dimension of actually the target. So in doing so, establishment of law in university is not sufficient, but who is teaching law? That is important firstly, and how is he teaching the law? That is more important than the person who is teaching the law. So we need to carefully observe these things in our region. Well, the second point, I almost said at the end of the time, well, I'm just summarizing a few other points. That is about the clinical education. Well, there is a popular argument about this particular clinical education that whether CLE should be taken as a method or as a program. Personally, I'm in favor of taking it as a method because, well, but I'm not denying the possibility of taking it as a program because I think that taking it as a program eventually will lead to taking it as a method. So if we can take it as a method that could be implemented in each and every law course, instead of having a separate law clinic only, so the students will learn, well, there is ethics that is in the law clinic room. Instead of doing that, I'm in favor of start taking it as a method in each and every course. Well, the third point that I'd like to focus on, that is about the teaching method, that the traditional lecturing teaching method is focusing on more on the text of the law. I think rather, that keeps away the students from the idea of justice, because, for example, recently Indian Supreme Court has pronounced a judgment regarding unconstitutionality of 3 talaq, that talaq 1, talaq 2, talaq 2, that has been declared by Indian Supreme Court to be unconstitutional. Well, if we teach that particular piece of law to the students of the world, that this is something unconstitutional, that will put one impression in the minds of the student. But if we do that in a different way, from a case perspective, setting a woman in the context, then the students will just imagine that law from the application point of view. So that traditionally, since we belong to commoner country, so British education has been more, that method has been more followed in Bangladesh or in a country like India, I think. So instead of that, if we could introduce more case-based method, because I think that case-based method has a better link with making the idea of legal education more justice-oriented. Well, the last point that, can I take another just 2 minutes?
Yeah, you have 3 minutes more.
Oh, still 3 minutes?
Yes.
Okay, fine. Well, because I really wanted to tell something about law clinic in Bangladesh. Well, the history of law clinic is that, for example, me personally, a product of law clinic. When it was first introduced in Bangladesh back in 1996 or 97, 94, okay, 94. And I did it in 1996. So I'm the product of law clinic. And if someone asks me, what is law clinic? I used to think in my student that, well, law clinic is something that is a Ford Foundation project. Well, because it was funded by Ford Foundation. And that there is a popular belief in the minds of modern clinicians that funding sometimes is helpful, funding sometimes kills CLE. And that has happened in case of Bangladesh. Because it was introduced in 1994. Then after a decade, it was stopped. And no one knows why was this stopped. And I used to ask my professors, why it has been stopped? Oh, the simple answer is that because the Ford Foundation has stopped funding. So don't we have any other responsibility to continue? So that was one of the main reasons behind the failure of law clinic in Bangladesh. Because in that 1 decade, it couldn't achieve much. And it was stopped. Then it was reintroduced just 3 years ago. Now me and Professor Tawhidul Islam, we are coordinating the program. And taking a lesson from that particular experience, the first thing that we are doing and we have done so far, that we are trying to incorporate it into our curriculum. And for the first time in 2019, we have got a funding from Dhaka University Central Fund for the first time, which is to be being used in 2020 in implementing some of the fieldwork activities, community engagement of the students. That is a small amount of budget, but we are happy that it has been integrated with the university main activity. Well, another problem in the CLE program is that sometimes some people become engaged with this type of training, and later they just pull some activities from here and be engaged with the NGO activities. So that is one of the serious concern about clinical education, especially community work. When the students become involved in the community work, if that is done simultaneously with an NGO, then sometimes there is a hazard of being treated as an NGO activity. So it should be more linked with the university learning. Well, there are some of the reasons that we need to consider from Bangladesh perspective. That the first one is financial dependency. Clinical program was misconceived. Failure to take it as a method. Failure to develop proper module. Failure to develop clinical teacher. Making it as an NGO activity. And failure to integrate it in the curriculum. Well, presently, there is a curriculum committee, and me and Professor Tohe both are the members of that present curriculum development committee, and I'm also acting as an additional director of the IQAC project that is funded by the government for the development of curriculum. And we are trying to integrate it, though not possible in a credit course, but at least in a non-credit course form in our curriculum. I hope that that would eventually bring some success for clinical education program in Bangladesh. Well, the last sentence is that I'm hoping to integrate it into our curriculum and to take it as a method in the overall, in the total legal education system, and such type of regional conclave will be much helpful for all of us. And thank you very much to the organizers for organizing such a wonderful conference at this time. Thank you very much.
Thank you so much. I know you're pitching from conference to conference, but we would have really benefited from having you here yesterday, because some of these issues did come up, and you started with good law and bad law, and talked about justice education as, not just promoting good law, but also bringing about good outcomes. And in fact, yesterday, I think Gagan had gone further and said, the good outcome may happen because of law, or it may also happen because of some other disciplines. So we have to use what tools we can get. So I'm so happy to hear that the clinical program has restarted in your university, and I really wish you the best. We now have two speakers talking to us about reinventing legal education in India. May I suggest that, just check if your mic is not working, you can probably use this one. We don't need a mic basically. So let me introduce Pooja and Soni. Both of them are from the Central University of Gujarat. Pooja is a research scholar working on legal education, and Soni is part of the faculty there. So welcome to both of you.
Because I have a very short time to explain whatever I have drafted since last week or so. I would just quickly thank everyone for making me part of this beautiful conclave, and I had a good opportunity to conversate with all of the intellects. I'm hardly anybody to speak upon this issue because I don't carry that much of experience with academicians. I have been working with the legal field for 5 years as a practitioner, but I have not been with the academicians. Hence, this is an opportunity where I got to know what are the academicians and what are their perspective over the legal education. So I thank all of you for making me part of this conclave, especially the organizers and Nirma. And it is really an opportunity for me to be part of Nirma as a student and also as a guest. So that phase is very much happening for me. Now coming directly to my subject, we have already on the last occasion we discussed everything about the legal issues. I would just sum up all of the ideas and I would give a heading to it. Like when Ekakshara, Usha ma'am and Vedkumari ma'am said that who will take up the issue. So that is the first thing that we have to take care is self-discipline. If I am disciplined, if I am aware of what I want to take away and what I want to have a rebellion on or a revolution on in legal education, that it is the first one. I am the first one who has to take it. So that is the self-discipline portion that I will take. That is the issue. Also, it can be a solution if you personally resolve to take something here. Then we come up with a gap that there is a shared experience issue with the legal education system. You don't have inclusiveness. There are 3 pillars of the legal education system, which is one is the students, then other would be the justice seekers, and the other would be the justice doers. It is not limited to these 3. It is also limited to the society. It is also limited to the parents who are sending their students for legal education. Or maybe they are enforcing them to come up for the legal education. So they also should be given a participation chance, and that experience also should be taken. Even I had a word with Abhiraj that next time, if you can organize, we can have a conference with students as well as their parents, so that they also can come up to some conclusions, some inferences we can draw from them, that what are their difficulties and what are their ideas about sending their students to a legal education class. Then comes that there should be a collaboration, which I have already included in my shared experience portion. And it's also about accessibility. Accessibility in all includes affordability. The education should be affordable, then it should be available and understandable. And finally, I would say that if all these aspects are taken care of, then only you can realize the actual idea of clinical legal education or say justice education. If you have shared experiences, if you have accessibility of education, if you have training in your courses, if you have collaborations of everybody, societies. Law is the only field which is attached and attracted to all the fields. It is not just limited to law, and hence there should be inclusiveness. And that is perhaps where Anup sir said that where would funds come from? Inclusiveness will bring funds to the entire concept. On the last occasion, even Mohammed Islam sir has highlighted something about UK model of clinical legal education to be infused, and he has very well said that they have legal practice course and bar vocational course. The fantasy of the UK model is such that they have these courses as mandatory course. You can get the degree only and only after you have pursued this course. You have passed through this course, and it is not limited to that course. You also have a special qualifying examination for this. So if we infuse such kind of course in our course curriculum, then in that circumstances, if it is mandatory, each and every student would participate into such kind of clinical legal programs. The other fantasy that they also have is a continuous legal program, continuous legal education program. They familiarly call as CLEP. CLEP is an initiative which is taken into consideration for all those who are practitioners in law, who are professors in law. So they have incorporated this. Then quickly I'll come to my 5 law techniques. First is the continuous legal education, which I've already said that you should infuse continuous legal education even for practitioners, for academicians. And on that occasion I would say that as Asha ma'am said that there should be sustainability. If there is continuous and if it is mandatory, then sustainability will be ensured. So it should be continuous plus mandatory. Then you should have a justice workers course, as rightly Gagan sir has highlighted that they should be called as justice workers. Then if you want to title a legal practicing course, you can title this as justice workers course. And then as you rightly said that there should be workload realization. This course can entail workload realization, and also students can be given credit, also parents can be, and the civil societies can be incorporated so as to ensure inclusiveness. And I have 2 more suggestions for the same, 2 more techniques where you can put clinical legal education and justice together. You can have a special qualifying examination, you can improve the AIB exams by incorporating case study methods and all. And then you can promote skill-based education. It is not just about the legal education that you are providing. Your law is connected to so many other fields. So you can incorporate art, science, humanities, economics and finance into the course curriculum. Thank you. And I had Soni.
Yeah. Continuing with this same presentation, before that let me introduce myself. I am Soni Kunappan. I teach at Central University of Gujarat. There is a center called Center for Studies in Social Management, where we have some of the similar courses. Like one of the courses is on institutions, governance and justice. Unless and until yesterday I was discussing some, unless and until we don't think about the institutions and its capacity, what are we talking about this goals? How do we reach there when our institution itself is problematic? So I think somewhere we need to look on that. The other course which I teach there for the PhD program is on criminal justice, social work and policy, and the third one is on administrative reforms and new public management. Now coming to the topic is that taking from her, she has described the techniques and getting into the tools that are required to facilitate these things. These are just some of these things which has been taken from the UK models. Maybe we could do a proper project. Maybe this forum could take it up forward for a project by getting the feedbacks from different stakeholders and then incorporating the same and then taking up to the policy level so that changes can be brought in, not just the cosmetic changes. What I am looking forward for a regulatory changes and incorporating those things which Pooja was or we all were discussing. One is to have access to education. Let us see how to get what about our law schools? Who can get into these law schools? What are the backgrounds from where? If you look into most of us are, some of us are teachers in the law schools. If you look into the background, what is the capacity and the class of students coming there? And how do we define this examinations into these systems? And how do we ensure that it could be more open and more affordable? and that is one aspect of tools. So how we need to set up strategies where it could be open to or access to all in terms of education itself, legal education itself. Second one is installation of centrally codified uniform standards of education. We don't have as such. We have certain jacket system which is coming from the Bar Council, but we need to strengthen it by having inputs from various subjects, not just about the narrow looking of law from the lawyers or the law profession itself. Now then one more thing which we need to look in, even the Bar Council has taken up, Bar Council to resolve mandatory stipends to the new entrants in the field of litigation for an initial period of 2 years. This was discussed, or this was taken up by the Bar Council, and a press release was made on 12th February 2019 on demanding stipends for the new entrants. Some of money has been set aside. So this, they said that there will be a committee which will be looking into it. So can we think on that? Just after completion of this course, 2 years. They have talked about 5 years, at least 2 years of mandatory internships, or not internship, I would say, a proper training with the courts and court systems. Then participation, contribution of institutions of law and research and policy. This forum GATE forum can take about or pitch in contributing this. Some of the suggestions, to be very specific to what we were discussing, was that now the scheme of the years of the courses could be people who are coming after +2. Can we think about having a 4-year of regular course, 1 year of proper justice workers course, wherein what you are talking about, the methods you would be teaching in all the courses. Maybe that would be a practical session of 1 year justice workers course and then a 1-year training program, so that this can be properly schemed into our legal education or justice education system. And those who are coming after 3 years of graduation, let that be a 2-year of regular courses, and that needs to be discussed in detail on how we ensure it, but bringing in issues of bringing in disciplines of management, litigation skills, arts. We have a course on criminal justice social work. Now, last week we had met at this to develop a specific manual for these criminal justice social work and to spread it across as one of the specialized component of social work education in India. How can we bring or take up those things? Because today morning, Professor Rao was talking about most of the things which we have dealt with at the Center for Criminology and Criminal Justice. So how do we incorporate those into the system? Now, one more important point, which because Anup was discussing about how do we raise fund. So can we think about CSR? There are lots of law firms which are working. So can we think about CSR compliance to it and then bring out fund through CSR activities? CSR funds can be brought in to these things. So these are some of the things which I would like to put across. To conclude very specifically, I still, from the first day itself, I was discussing, I was putting or throwing across these questions. Are we seriously, this group is seriously looking at a small cosmetic changes within the existing framework of legal education in India? Or are we serious to negotiate, to discuss, to take it forward with a proper solid research study conducted by people across and take it forward to redesign the whole curriculum and the scheme of law education so that justice is delivered to the most marginalized section of